All right, so here we are at the after-school review for the Supreme Court. We're going to take a look at the development of the court system and some of the more important court cases that dealt especially directly with U.S. history. Before we get started with that, I do want to start with a particular court case that happened during colonial period, the Peter Zenger trial. 1733, Peter Zenger. This is right at the time period of the First Great Awakening taking place in America. Zenger owned a newspaper, and the newspaper criticized the royal governor of New York. Zenger himself actually did not. There are actually two other men who were writing anonymously, and Zenger published it. What happens is, under British law, you're not allowed to criticize government and authority. You're not allowed to do that. That's considered libel. Even if what you say is the truth, it's still libel and punishable by law. The problem is that every person in New York basically comes under the control of the royal governor. So Zenger was not going to get a fair trial until they were able to get themselves a Philadelphia lawyer, this guy named Andrew Hamilton, he's from Philadelphia, and he's able to do something quite interesting. What he winds up doing, instead of figuring out if Zenger's innocent or guilty, because really under the law he's already guilty. It's printed, once it's printed, it's libel under British law. Hamilton argued not towards Zenger's innocence or guilt, but was the law fair to begin with? He began to argue or put the law on trial. He began to tell the jury they have the right to nullify unfair laws. Jury nullification begins in America. And they wind up ruling in Zenger's favor. It's the beginning of freedom of press and freedom of speech. So I like to put that particular lesson here during the Supreme Court. It kind of meshes up nicely. The beginning of America's understanding of how law should work, very, very different than that of Europe. Right? In America, you're innocent until the state proves you guilty. In Europe, you are guilty until you prove your innocence. And there's a huge difference in that. Right? In America, law will develop quite differently than what is in Europe. All right, well, let's look at what is the role of the courts. There are two types of ways that a court should act: judicial activism, judicial restraint. Should judges be very involved in society? Judicial activism. Should they take an active role, seeking to try to correct some of the social problems? So they allow their own personal beliefs, their own political thoughts to rule them. This falls in the area of that loose construction. Or should they be strict constructionists and show judicial restraint? Limit their exercise of power. Only look at cases that they know specifically deal with constitutional problems and not particularly social ills. Some of the court cases that we're going to discuss, some of the famous ones that we've been discussing for a while, you're going to see where the judges were very active, where they showed restraint. Sometimes judges don't even want to listen to certain cases. In your day, in 2013, the Supreme Court does not want to listen to under God. Okay? They don't want to listen to under God. Right? We all know that's a Pledge of Allegiance. The California Court of Appeals has ruled that unconstitutional. The father who brought that before the courts back in 2008, he's an atheist, and he didn't want his daughter saying that. The courts did not listen to it because the parents were divorced, and the daughter was actually in the custody of the mom. So the Supreme Court ruled that the father had no custody of his daughter, thereby had no standing. They showed judicial restraint and would not even listen to the case. And thus far, they're still showing that. They don't want to pick on that particular case. Judicial activism, as we'll see later on, is like with the Brown case, right? Brown versus Topeka, right? Where the courts got very active, they got very socially minded, got very involved. All right, the composition of the court. Judicial branch is created under Article 3. Right? Article 1 creates which branch of government?
Legislative.
Legislative. All right. Those of you who are brave enough to say it out loud. So Article 2 would create what branch?
Executive.
Well, yeah, I thought I'd get more people saying that since there's only one left. But yeah, the executive. It's the Judiciary Act, 1789, that first establishes the entire court system. The way the Constitution read in Article 3, it really didn't define what the entire court system would be like. So the Judiciary Act 1789 clearly defines the entire role of the courts. And also at first appointed 6 justices to the court. Currently, what is the number today?
13?
9. 9. Why 9? Why odd?
So there's no ties.
So there can't be any ties. That was established in 1869 in the Circuit Judges Act. Congress officially established 9 justices, with obviously one of them being the Chief Justice. Now the first Chief Justice of the Supreme Court is our forgotten founding father. We often forget about him, John Jay. What else is John Jay famous for? Federalist Papers. He may have wrote a few of the Federalist Papers. Do you think of anything else?
He had that.
He was an ambassador. He has Jay's Treaty to his name. Exactly. That's during Washington's administration. Jay's Treaty was with what country?
France.
Not France.
Spain.
Not Spain.
Britain.
Great Britain. Piccaninny's Treaty is Spain.
Oh,
All right. John Jay was also one of the initial diplomats who signed the Treaty of Paris 1783, thus officially ending the American Revolution. So John Jay has had a lot to do in our American history early going, but we forget about him. John Jay did not like being on the Supreme Court. The Supreme Court in the very early going was really treated like an unwanted stepchild. It was, the presidents didn't respect it, the Congress didn't respect it. The first year they met in the back of a tavern, right? That's where they held court, was in the back of a tavern. Fights would break out in the bar and would spill over into the chambers of the Supreme Court. This is why Jay just did not like being on this court. Eventually they put the Supreme Court in a room in the Capitol building. And it stayed there until 1935 when they finally got their own separate building. Stayed in Congress, right? Stayed at the Capitol building so Congress could keep their eyes on the court. And that was very important to them. The only real big case that John Jay ever presided over is Chisholm versus Georgia. And this is a situation where you see checks and powers on the Supreme Court. Remember what checks and balances are? Yeah, someone's phone goes to ringing. Checks and balances, right? Right? One branch of the government checks the power of the other branch of government, right? Mm-hmm. So if the Supreme Court makes a ruling, and they say, okay, this is now the law, how does Congress check the power? Well, not making any amendment. Making any amendment. That's how you check the power. So here's a case where Chisholm was suing the state of Georgia. And he was not a citizen of the state of Georgia. Interpreting the Constitution, he allowed for this lawsuit to happen. This became law. You can sue the state. Congress got involved immediately, and they got the 11th Amendment gets proposed and ratified. Right? You cannot sue states. But there's certain issues that do come up that do allow you to, but under normal circumstances, you can't just sue a state. States have to be protected. So they had to pass an amendment to overturn this judicial decision. You do get amendments that will specifically overturn judge-made law. That's often the basis of our amendments. We're going to talk about some of them as we go along in this little study of history. The Judiciary Act 1801, the more controversial one. What election took place in 1800? Anyone remember?
Adams versus Jefferson.
Adams versus Jefferson, Part 2. Right? Who won the election of 1800?
Jefferson.
Jefferson. I like how you say that with a question. Are you sure?
No.
No? Pretty sure?
Kind of sure.
Kind of sure? This group over here isn't saying anything at all? Again, you're so worried about writing stuff down, you're not listening, is what's happening. Right? You're so worried about writing all these words down verbatim that we're not listening. So the election of 1800, Jefferson won that election. Right? That's when, if it's Part 2, Jefferson won. Adams won the first election. So Jefferson wins the second election. What political party was Adams?
Federalist.
Federalist, there we go. What political party is Jefferson? Jeffersonian Republican, that's what I want to hear. Very good, all in unison. That makes me feel good. Not only did the Federalists lose the White House, but the Federalists got stomped in Congress as well. They're going to lose the majority of all their seats. There will be a handful of Federalists that will stick around. But again, the election takes place in November. Do you remember in this time period when you actually March? Exactly, March. You wait till March. Same with Congress. Congress stays until March when the new Congress comes in. So you have December, January, February, and then halfway through March. You have a lame duck situation. We call it a lame duck presidency, lame duck Congress. But there's a lot of mischief you can do at this time period as well. The Federalists still are in power. So they've lost the executive branch. They've lost the legislative branch. They're going to try and hold on to the judicial branch. They passed this law. Now originally, this idea of writing circuit. We call these originally circuit courts. Today they're known as appellate or appeals courts. The same thing, same thing. Writing circuit, the judge who sat on the Supreme Court. Right? You don't sit there 12 months out of the year. You're really only there 6, 7, 8 months out of the year. The rest of the time, originally, they would have these judges literally get on a horse and ride a circuit to hear appeals case from lower courts. Well, there seems to be some inherent conflict of interest here. If you sit on a lower appeals court and you hear a case and you make a ruling now, then let's say a year later the other party doesn't like the ruling, so they now appeal it to the Supreme Court. You were the guy who heard it first at the appeals level. Now you're hearing it again at the Supreme Court level. Yeah, there seems to be some inherent problems here, conflict of interest. You've already heard the case once and made a ruling. Now you have to hear it again and see if your ruling you originally made will hold up or not. So the Supreme Court judges didn't like that. And obviously so. That's really kind of silly if we think about it today. Imagine today, the Supreme Court judges today, once they're out of office, June comes an end of their year term, they all then flew around the country listening to other appeals cases. Right? That just doesn't make sense. So originally this law was supposed to fix that. But the Federalists also took advantage and then began to say, hey, let's control the entire judicial branch. Right? Let's just keep adding numbers of federal judges here. 16 new judgeships at the district level and the circuit level, plus a plethora of judicial positions elsewhere, like Justice of the Peace. There's something called Justice of the Peace. That is a traveling small-time judge. They added several of those as well. Right? They tried to get as many Federalists in the judicial branch as they possibly could. This is that famous midnight judges. Why is it called the midnight judges? Because he's signing their commissions. But is he really signing at midnight? No, it's like 9 o'clock maybe, or 8:30. That's not as, like the 8:30 judges. Sometime around 9:01, we stop signing judges. This sounds a lot more, that sounds cool, the midnight judges. Right? Adams is in his office with a candle, with a quill in his hand, signing all these commissions. Right? Yeah, he was done sometime between 8 and 9 o'clock at night. Yeah. But it seems like some corruption's taking place here, some mischief by calling them the midnight judges. And that now brings us to the famous Mulberry versus Madison situation, right? Mulberry versus Madison. Again, a very strange moment in our history dealing with our courts. At the time that John Adams is President of the United States, at the time the Judiciary Act of 1801 is passed, John Marshall is the Secretary of State. I don't know exactly why, but at this particular moment in history, Secretary of States had a lot of other things to do. And one of their jobs was, whenever the President had commissions that he signed, it was up to the Secretary of State to deliver and officially file them. John Adams has just appointed John Marshall Chief Justice of the Supreme Court on his way out the door. So Marshall is trying to clean out his office as Secretary of State while getting to his new office as Chief Justice. In the meantime, he forgets or he fails or somehow or another the commissions are not filed. They're left in a stack on the desk. There's Inauguration Day takes place. Thomas Jefferson's the new President of the United States. Yay, Jefferson! Who does he appoint Secretary of State? I have it on the board. James Madison. Remember James Madison? Thomas Jefferson's like 6'1", 6'2". James Madison's tiny. I always had this picture in my mind of Madison walking to his office, seeing these stack of commissions and realizing what's happening. Picks them up and runs. The sky is falling like Chicken Little all the way over to the White House. Oh, Mr. Jefferson! You got to see what they've done. He will not hand out the commissions. Jefferson tells him, we're not going to honor these appointments. Now, this becomes a matter of law. Who gets to interpret the Constitution? Well, Jefferson as president believes he does. Right? The new Congress, the new Jeffersonian Republicans are in place. They believe they get to review this law. This becomes an issue of who has the right to make law, enforce law, review law. Jefferson actually goes so far as to order the Supreme Court not to meet for 18 months, almost 2 years. They don't even meet. He orders them to ride circuit instead, bullying them around basically. There's this whole basically standoff now between the Supreme Court and the President of the United States. The Supreme Court could rule that Madison broke the law. Thereby, Madison needs to be impeached. If Madison gets impeached, well, who ordered him to break the law? Jefferson. Then Jefferson's impeached. At the same time, Jefferson and the Congress is threatening to impeach members of the Supreme Court. They've already filed up impeachments against one Samuel Chase. He's a member of the Supreme Court, and they're going to impeach him because of the Alien Sedition Acts. Remember the Alien Sedition Acts? Yeah. Right? That's when the Federalists were in power. Now the Republicans are there, and they want to get even. Right? They want to get back at the Federalists. So they have now filed impeachment against Samuel Chase. It will never hold up. Samuel Chase will never actually get impeached. Right? But there's this massive showdown. That's why this whole time period, remember this time period is known as the critical period. We call it the critical period for this particular reasons and other reasons. During Washington's time, we think France might drive us apart. We don't know if we can enforce taxes. Now we're in a situation with judicial law. Who has the right to interpret? Are the Republicans and the Federalists going to start shooting each other? Marshall, very calmly, he's now the Supreme Court Chief Justice. He made the mistake originally, now he gets to fix it. And he does it in a very smart way. Mulberry, William Mulberry, was supposed to be a justice of the peace. That's his commission that he didn't get. He and several other guys as well. It wasn't just Mulberry, it was like 4 or 5 of them all together. They immediately appealed to the Supreme Court. Well, the Supreme Court had to stay out of session for almost 18 months, almost 2 years. 1803 is when they finally hear this case. And Marshall's taken all this time to prepare for this, What he winds up doing, after he hears what their reasoning is, what matter of law was violated, Marshall then orders this case to be thrown out. He orders the case to just be thrown out. Okay? Because he says Mulberry did not go through the proper channels. He should have taken the case first to the district courts. Heard it first in the district, then at the appellate level, and then eventually the Supreme Court. Thereby he has no standing. So there's a point for Jefferson. All right? They threw the case out. But before he's done, he then says, it is emphatically the province of the Judicial Department to say what law is. And this establishes judicial review. He gets to say on record, in his opinion, that only the Supreme Court and courts in general get to actually review law. Not the President and not Congress. Jefferson's not exactly happy, but he abides by it. Right? Presidents will ebb and flow with the Supreme Court. They don't always like them. Sometimes they try to overthrow them, as we'll talk about a little bit later on. Right? You might remember some situations that get very testy with presidents in the Supreme Court. But for the most part, you've got to accept their decisions. Let's talk about Marshall and his court. Nationalism. Marshall, remember, he's also a cousin of Thomas Jefferson. They were cousins. That has got to make for an awkward family reunion. Right? No. What did you do over the summer? Well, I almost put my cousin in jail. States, remember, this is a time period where we're still not sure who's more powerful, the central government or the states. Compact theory is out there. Jefferson threw out compact theory several years earlier. It is gaining traction in the states. Marshall, being a Federalist, believes in a strong central government. Marshall served in the Revolutionary Army. He served at Valley Forge. Right? He saw what happened when Congress was ineffectual. Men starved, men froze at Valley Forge. Marshall did not believe in a weak government. He believed in a strong government. And so many of his rulings, this is judicial activism on his part. Okay? He gets very, very highly involved. And there are several cases, and earlier in the year, if you remember, you guys did a homework project on this, where you had to look up all these various cases. I put 3 of the more, I thought, important ones. McCulloch versus Maryland. Right? This dealt with the Bank of the United States. This was the second bank of the United States, actually. Right? The second bank gets established in 1816. In 1819, you have a panic. Right? You have the first panic in American history. The bank did not protect state banks like it was supposed to. It itself panicked and was afraid of going under, so it decided not to get in there and get more money out there, get money into circulation. They decided everyone on their own. This angered a lot of people. It angered the good people of Maryland, a southern state that does not like the bank. So they decided, we're going to start taxing the branch. Right? It's just like any bank. You know, the Bank of the United States, located in Philadelphia, it has branches in every state. Just like any bank today, right? How many of you bank with what? Wachovia? Anyone banks with Wachovia?
Wells Fargo.
Wells Fargo. That's right. It's Wells Fargo now. Yeah, don't even keep up with that myself sometimes. You know, what's another bank?
Chase.
Chase, Bank of America. And they all have
HP
branches in all
Morgan.
these multiple states, right?
BB&T.
Yeah,
HP Morgan.
exactly. There you go. So it's the same thing. Bank of the United States has branches in other states. Maryland's going to start taxing theirs. McAuliffe is the branch manager of the Bank of the United States. So it's McAuliffe or the bank versus Maryland. Goes to Supreme Court eventually. Trying to put this tax. Yes, Elizabeth.
Didn't the 11th Amendment say you couldn't sue a state?
Can't sue a state. This is the state suing the branch.
Oh.
That's what's happening, yeah.
Well, okay.
Yeah. It's not a person,
And then
he
it's
represents
the
the
same for
bank.
Cohen's in Virginia?
Yeah.
Okay.
This is, well, no, this is different stuff. We're gonna talk about this is all different things.
Right.
Let's wait till we get to that. But
Okay.
Marshall makes an interesting decision. He sides with the bank. He says that Article 1, Section 8 says that Congress can make any law they deem necessary and proper. And that's what Alexander Hamilton used to create the first bank. This is what we're using to create the second bank. So it's already constitutional. It's already been established as a rule of constitutional law you can have a bank. Plus, he wants to make sure they understand that the power to tax involves the power to destroy. So if a state wants to tax something, that means they can also destroy something. Well, we cannot allow that because the power to create implies then the power to preserve. So since the Constitution created the bank under Article 1, Section 8, then the government has a right to preserve the bank at all costs and shoot down Maryland's right to tax. The central government is more powerful than the states. See how this starts to anger Southerners? Right? Because if these cases, remember, every time these cases come up, what was always the natural conclusion to a Southern mind?
Slavery.
Slavery. It would always come back to slavery. If they can deny us the right to tax a bank, they're going to eventually deny us the right to have slaves. It always came back to that. Cohen's versus Virginia. What happened here is by act of Congress, they allowed for a lottery to take place in Washington, D.C. Right? They're lottery tickets. You guys probably, any of you buy lottery tickets? Or you're not old enough, right? I don't think so. But your parents buy lottery tickets?
Sometimes.
Yes.
Hundreds of millions of dollars that you'll never see ever. Right? What a waste.
They're tax
So the Cohen brothers, these Cohens, they decided they would also sell lotteries in the state of Virginia. All right? So they left Washington, D.C. The law was you can sell lottery tickets in Washington, D.C. They start selling in Virginia. Virginia had a law that you can't sell lottery tickets here. All right? They get arrested. They go through the court system. Right? This is why it's Cohen's versus Virginia. Virginia has arrested them. Okay? They argued that since Congress passed this law, their law supersedes the state law. Right? Goes always, but Virginia found them guilty. Right? Once it went to the Virginia State Supreme Court. Remember, every state has their own Supreme Court. The state Supreme Court upheld the Virginia law. John Marshall decided, okay, I also want to hear this case. So he also, after the state Virginia Supreme Court had its ruling, he then listened to it as well. He upholds Virginia. Okay? But what he's doing is he's proving that the Supreme Court of the United States supersedes every state Supreme Court in criminal law. You can have a decision in a state court, but if the Supreme Court thinks that you didn't do what was right by the Constitution, the Supreme Court has ultimate jurisdiction. Right? That's why he wanted to hear that case. He knew that they ruled right, but he wanted to prove a point again. Supreme Court, the central government, more powerful than state courts. Again, you see why Southerners are getting very scared of this strong central government? Gibbons versus Ogden, a very long, convoluted case. All right? It deals with the rights to sell steamboats. There's a new technology out there. Robert Fulton and a couple other people are going to business trying to get steamboat lines and canals. You know, like later on it'd be railroad track. Who has the right, what train company has the right to be on this railroad track? Right? In their time period, what steamboat company has a right to sail up and down the river, up and down canals? So So they're trying to monopolize these things. There's these companies coming around trying to monopolize. Ogden is the governor of New Jersey. Gibbons represents a company out of Georgia. And it becomes this whole big thing about who gets to have a monopoly, who doesn't. Who gets to decide who regulates interstate trade?
Congress.
Congress, right? So that's where this falls into again. Only Congress has the right to basically oversee interstate commerce. And that's again one of the main things here, proving the power of the central government. That was Marshall's whole big thing as he was judge, or Chief Justice of the Supreme Court. Of course, his last big thing is kind of a failure, led to the Trail of Tears, right? You get Cherokee Nation versus Georgia and Worcester versus Georgia. One is judicial restraint, the other is judicial activism. Georgia wants Cherokee land. Right? That's where this basically comes down to. You have the 5 civilized nations, the Cherokee, the Choctaw, the Chickasaw, the Creek, and the Seminole. And they've passed the Indian Removal Act, 1830, throwing all these Indians, including the 5 civilized tribes, out of the country. Where do they have to go? Well, they had to go west of the Mississippi. Most of them had to go to Oklahoma. The Cherokee were going to have to go to Oklahoma. Yes. Cherokee don't want to go. The Cherokee have treaties signed with the national government. So they do what every good American normally does. They take the matter to court. Cherokee Nation versus Georgia, 1831. Well, are the Cherokees citizens of the United States?
No.
No. You have no standing in court. It's called standing. You are not a legal citizen. You cannot sue. Now, John Marshall did think that the Cherokee were getting a raw deal, but he had to show restraint here. Right? This is restraint. So he winds up dismissing the case. You can't sue the federal government. You're not citizens of the United States. Enter Sam Worcester, who moves onto Cherokee territory, starts working amongst the Cherokee, claims that he's a missionary. Georgia has a law that white men cannot live in Cherokee lands. He's arrested. He goes to jail. He starts making large rocks into small rocks. I mean, it's really going to be a bad thing for Sam Worcester.
What does that mean?
I'm just making a joke here, Dave, okay? Just trying to make a joke. He's an American citizen. He's an American citizen, okay? He can sue. So he's suing not only for himself, but really on part of the Cherokee Indian. Here John Marshall can now check himself. He winds up overruling Cherokee Nation versus Georgia. He says that the Cherokee now do have rights to these lands because they've signed these treaties with the United States government. An official government of the United States has signed official treaties with the Cherokee just like you would with a foreign nation. How does the federal government respond? Does the federal government allow the Cherokee to live there?
No.
No, right. Who's the President of the United States?
Jackson.
Andrew Jackson. How does Andrew Jackson think about the Supreme Court? Doesn't really like it. Now there's that saying that he supposedly said the Supreme Court or John Marshall's made his ruling, let him enforce it. More than likely Jackson never said those words. Somebody else said it. But Jackson did have some words about, states' rights. State still has its right to enforce law. And so the federal government sends troops in, and the Cherokee are forced to march. 20,000 plus, over 2,000 of them die along the way. The Trail of Tears. Right? Trail of Tears. John Marshall then passes away. Andrew Jackson gets to appoint his own Chief Justice. The guy, he was Secretary of the Treasury, helped him destroy the second bank in the United States. Roger No, Roger Williams.
Tanny.
Roger Tanny, yeah. Roger Williams is a
1600s.
separatist living in Puritan England, New England, right? Yeah, Roger B.
Word
Tanny.
association.
Yeah, words, yeah. Roger Tanny. We get to the Tanny Court. Roger Tanny. Interesting person, Roger Tanny. Three famous cases take place while he's serving on the court. The Stead case, 1841, that dealt with this ship, a Spanish ship that had illegally purchased Africans as slaves. Great Britain has already outlawed the Atlantic slave trade. Spain went into an agreement with them on this. England, Great Britain, and Spain have outlawed the Atlantic slave trade. It's against the law to sell slave ships. The United States entered into that agreement with them and said, all right, you're right, we'll enforce the slave trade on the Atlantic Ocean. These slaves wind up overpowering the ship and kill most of the crew. The crew that survived, they threatened them, they ordered them to take them back to Africa. At nighttime, the crew kept sailing north so that the Africans didn't know what was going on. They wind up in the north part of the United States where they're captured. They're taken for the murder of this crew. Now the issue becomes, they were meant to be slaves. You're in a nation that has slaves. What are you going to do? Great Britain begins to put a lot of pressure on the United States. You must acknowledge and enforce international treaties that we've all signed when it comes to the Atlantic slave trade. This case will be tried in lower courts and eventually the Supreme Court. Do you remember a president by the name of John Quincy Adams?
Yes.
He's our only former president then to go into the House of Representatives. He spent the rest of his political career as a member of the House. He also will try this case as the defending attorney for the African slaves, arguing that America has entered into this non-slave trade agreement on the Atlantic Ocean. We must honor our international treaties. That they were illegally bought and sold. Supreme Court upholds that. So there will be several families in the New England area. Obviously, this is the era now of abolitionists are starting to emerge in America. They will have these men, these slaves, these Africans, I should say, live in their homes, feed them, take care of them, and then eventually help them to go back to Africa. And many American missionaries will go back with them to help establish them back into Africa. But the Prigg case is a very important precursor to what's about to happen with the Dred Scott case. This is, again, one of these strange cases. It starts in Maryland, where you have a slave owner who has this particular slave, this female, Margaret Morgan, who he has never treated like a slave. She's basically lived her whole life, basically as a free woman, although he never has legally emancipated her. And she travels all the time. She leaves whenever she wants. She has children, grown children, that live in the state of Pennsylvania. Well, she decides to go visit her sons over there, and she doesn't come back for a long time. The original owner, the family, wants to start selling off some of the slaves for money issue, and they realize that this woman is left, and they want her back. So they hire a bounty hunter, an Edward Prigg. His name is Edward Prigg. He's from Maryland. He's a bounty hunter. He's gone into Pennsylvania. He brings a little group of men with him to hunt her down. What law is out there that allows him to do this? The fugitive slave law is out there, right? There's a fugitive slave law. You're a runaway slave. Your property, we have a right to go fetch you. So Prigg goes into Pennsylvania. Under cover of night, he finds out where she lives. Not only does he capture her, but he captures her children, including one of her sons that was always born a free man. He was never in slavery. He also is captured. They bring them all back to Maryland, sell them all back into slavery. Pennsylvania then goes after and arrests this man. Because in Pennsylvania, that's against the law. So Prigg is brought back to Pennsylvania to go to jail. Prigg now begins to argue that his constitutional rights, I have a right under the fugitive slave law to hunt fugitive slaves wherever they go. Pennsylvania doesn't have a right to claim we're a free state, you don't have a right to come here and get us. This goes before the Supreme Court and Roger Taney, a racist, right? Remember this. Article 4, Section 2, Clause 2. That's what establishes slavery in the Constitution. They don't ever use the word slaves. This is Article 4 of the Constitution. It says, whenever there's a person held in servitude and tries to escape by going to another state, they have the legal right to go get them. You've got both slavery in the Constitution and the fugitive slave laws in the Constitution under Article 4, Section 2. Right? It doesn't use the word slavery, but it's clearly defined. Whenever someone's held in servitude. Right? Roger Taney says under this article, there's a fugitive slave law. Prigg did his job. Right? Runaway slaves must be caught and brought back. He's already set a precedent. Roger Taney has set a precedent here that slavery is constitutional. So that's when we get to the Dred Scott case, right? By now we've heard this case multiple times, right, over the last 2 weeks. We've talked about Dred Scott in various different ways, right? Here it is specifically with the Supreme Court. His owner moves to free territory in Illinois. Then they move again to Wisconsin. Actually, a free state was Illinois. Free territory was Wisconsin. The owner dies. He claims the rights of a free man. Not so fast, right? Mississippi wants him back. Actually, Missouri wants him back. They want to sell him back into slavery. The matter's taken before the Supreme Court. Again, this is a matter that does go through the lower courts. It works its way up to the Supreme Court. Immediately, Roger Taney dismisses this because he's not a citizen of the United States, just like the Cherokee Indians, right? You're not a citizen of the United States, you don't have a right to sue. So it's dismissed immediately. But Taney doesn't stop there. Taney then says the Fifth Amendment guarantees you the right to property, right? And that the federal government, the Fifth Amendment deals with the federal government. It says federal government without due process of law cannot deny you the right to property. And slavery is, in effect, property. There is no such thing as a free state, slave state. I can take my property anywhere I want. He then rules that the Missouri Compromise, although it's already been repealed, what repealed the Missouri Compromise?
The
Kansas-Nebraska Act, exactly. Even though it's already repealed, he now says this was unconstitutional. This angers people in the North, right? This is going to be a direct lead to the Civil War now. Who's the President of the United States?
Buchanan.
Buchanan, James Buchanan. Remember what James Buchanan winds up doing here? Shaking your head. What?
Yeah, he paid one of the North judges to cast his vote, so I won't see that it was like a Southern ruling.
Right, he gets a Northern judge and convinces him to change and side with the Southerners. So instead of a 5-4 vote, we get a 6-3 vote. Right? Basically, jury tampering. Basically, an impeachable moment for James Buchanan. Right? Thank you, Chantel. I'll say your name on tape. Yeah, this is a major moment. See, the Supreme Court is very influenced by Southern society at this moment. You have a Southern a court, basically. You have 5 Southern judges. The Chief Justice himself is a Southerner. They believe in states' rights. They believe in slavery as the basis of their economy. And between the Prigg case and the Dred Scott case, they wind up making sure that everybody knows slavery is part of the Constitution. That's why we're going to get an amendment that's going to make sure that it's no longer part of the Constitution. Do you remember what amendment makes sure that slavery is no longer a part of the Constitution?
13th.
13th Amendment. So we can take a pen and cross out Article 4, Section 2, Clause 2 gets crossed out. There's still in Article 4, but Section 2, Clause 2 is gone.
So is it just like taken out? Or?
Well, it's not like they go into the piece of paper and dig it off.
I feel like it's just
But
ignored.
we know it's ignored now, yeah. In fact, if you look at the back of your textbooks, usually they'll have it and they'll put usually a line through it to show you this part by amendment has been changed,
Okay.
right? Like Amendment 12 changed the process for electing presidents. It used to be in the Constitution, it said whoever got the most electoral votes, president. Whoever came in second, vice president. Well, Amendment 12 changes that, right? So amendments often, well, they do. They change the Constitution for us. Hello. Oh, there we go. All right, so some other very notable cases then that we've talked about from time to time in class. You have during the Granger movement. Remember the Grangers? The National Husbandry, the patrons of the Grange. These farmers that had united, they were fighting against the railroad monopolies. There's two cases then that deal with this. Munn versus Illinois, the Wabash case. Do states have a right to regulate interstate commerce? Right? Here's a situation where the Supreme Court ruled yes. Because there's two types of due process. Remember I told you the Fifth Amendment guarantees you that the federal government cannot deny you the right to property without due process of law. Now we have a 14th Amendment. The 14th Amendment not only says that if you're born in the United States, you're what? A citizen. And it goes on to say, as a citizen, the state cannot deny you the right to property without due process of law. So the Fifth Amendment says the federal government, the 14th Amendment is the state. Right? So there are two types of due process. Procedural, the process by which you have a law. Do you have a law that you put into place that you could follow the process fairly, right? And you did. You looked at all the procedures of the law, and that's how you came about with your due process. Well, here the Supreme Court said yes. These Granger laws are looking at somebody who owns a private good. In this case, the Munn Company owned the private good of a train, but they weren't using it just for themselves, right? They were using it for the good of everybody. So when you take a private good and you use it for the good of everybody, you can regulate it now. We're following the procedures of that law. So they uphold the Munn case. You get 10 years of corporate lawyers getting very smart about these amendments and these due process laws, and a new one comes along, substantive due process. Was the substance of the law fair to begin with? One is, are you following the procedures of the law? The other one, is the law itself fair to begin with? And that's what corporate lawyers now begin to argue. They also now argue that the 14th Amendment says that people have the right of protection with their property. Well, what is a corporation? But a group of people. A corporation is a group of people. So now the 14th Amendment protects corporations. So Bill Gates is protected under the 14th Amendment. Apple is protected under the 14th Amendment. Right? IBM, Coca-Cola, they're all now protected because of this Supreme Court case, the Wabash case. They now argue that they're people too, they have the right to property. The states do not have a right to regulate trade because who does?
Congress.
Only Congress. So Munn is overturned and Wabash is established. Congress does act, though. For the first time in their history, Congress finally decides to start regulating monopolies. The ICC. Does anyone remember what the ICC stands for?
Interstate Commerce Commission.
Interstate Commerce Commission. Thank you, Christopher. So the first regulatory agency we get in America out of this case was Plessy versus Ferguson. Separate but equal. Remember, this was dealing with Plessy, Homer Plessy, and the rights to segregation. Supreme Court rules that Jim Crow and segregation is now legal. This is Wong Kim Ark. All right. We have a 14th Amendment, was established after what war?
Civil War.
Oh, that took too long. The Civil War. Yes, the Civil War. And the 14th Amendment says, hey, by soil, you are an American. Or by blood, you're an American, right? If you're born on American soil, you're an American. If your parents were Americans by blood, you're an American. 14th Amendment. Everyone assumed this applied to former slaves. Then America passed the Chinese Exclusionary Act. The Chinese Exclusionary Act. The only time America passes a law to say this ethnic group of people can no longer come to this country. What about the Chinese that were born here? Are they protected under the 14th Amendment? Right? Well, they didn't think so, but they are, right? This is what happens. Remember, he was born in America. His family had a business in San Francisco, but his parents decided they want to go back to Hong Kong. He travels back with them to set them up in Hong Kong. He comes back, no problem. He gets back into the country. Several months later, I don't believe a full year went by, he got to missing his parents. He went to travel back to Hong Kong and see him a second time. The second time he comes in, he said, whoa, 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 whoa. Chinese Exclusionary Act, pal. You can't come here. And he says, well, you know, I'm an American citizen. No, you're not. 14th Amendment. Oh, wow. Does that work for this? Because the 14th Amendment does not say, oh, only white and black. It doesn't say that. It says whoever is born right here is a citizen. This goes before the Supreme Court. The Supreme Court says, yeah, that's what the 14th Amendment says. The Chinese who were born here, later on Latin Americans, Hispanics who are going to be born here, other Asian groups, other Europeans who start to come to America, all of them, because of the 14th Amendment, are going to be able to declare birthright citizenship. Schenck versus the United States of America, that's right during World War I. Remember, these were the socialists and communists. He was the socialist involved with Eugene Debs. Remember our good friend Eugene Debs? He goes to jail. Schenck winds up taking control of the Socialist Party. He starts mailing out flyers using the U.S. mail, denouncing the war and telling young men do not enter the draft. He's arrested and he goes to jail for this. Remember, they passed sedition acts in World War I under Woodrow Wilson. Right? And this goes before the Supreme Court. And the Supreme Court rules it's a clear and present danger. If it becomes a clear and present danger, the federal government has a right to censor you, to stop you, to incarcerate you. That famous quote comes out here. Oliver Wendell Holmes, who's just one of the judges, he's not the chief judge, but he says you cannot yell fire in a crowded theater. You cannot yell fire in a crowded theater. You can't go when Iron Man 3 opens up in just a few weeks and sit there in the theater and go, oh, this will be so much fun, watch this. 30 minutes into it, 40 minutes in, everyone's all into the movie, and all of a sudden goes, bomb or gun, right? Because that's so funny. No, it's not. It's horrible. And then people go panicking out. Look at the world we live in now. You can't do that. You do that, somebody gets hurt. What if somebody has a baby and they get trampled? You can be arrested for murder. Okay? You cannot yell fire in a crowded theater. If it's a clear and present danger to society, to people, you can't do it.
Does this case start the idea of censorship?
Well, there's always been censorship, but it starts to lead to more governmental censorship until later on. I'm going to show you another case that comes a little later that kind of limits this. There are limits now to this case, and I'll show you that in just a few moments. The Schechter case, that's the sick chicken case. Remember, this is under the New Deal. We got the New Deal, the Great Depression New Deal, and they have that NRA, the Blue Eagles, right? You're going to have ceilings and floors, only so many hours and you can't pay any less than this, minimum wage is the floor, trying to encourage you to hire more workers. This poultry company is literally selling terrible rotten chicken. And they get in trouble with the health department. When the health department finds out that they're also not in compliance with the NRA laws, that's where they get in trouble. Now it becomes a Supreme Court case, eventually. And they rule, hey, their chicken doesn't do what?
It doesn't go interstate.
Doesn't cross interstate lines. The NRA doesn't work here. Plus, the Supreme Court went further and said, it's kind of unconstitutional to begin with. And strikes down the NRA. That's where Roosevelt goes kind of crazy and decides he's going to maybe just get rid of the Supreme Court, it seems like. He's going to up the number from 9 to 16. Right? We're going to add, how many, you're math majors? 9 plus 7 would be 6. So we're going to get 7 more judges. And then I'm going to take the original 9 and put shadow judges behind them. So as they get old and get ready to retire, we'll just get one right in there immediately. Take over the entire Supreme Court. This is a miserable failure for FDR. It looks terrible. He looks like he's trying to literally become a dictator. What's the only thing that saved FDR?
Another dictator.
World War II. Yeah, another dictator. Adolf Hitler, exactly. Very well put. All right. During World War II, what are we going to do with the Japanese?
Put them in internment camps
Yeah, why?
because they're traitors.
Because they might be spies.
Everyone knows that was Ryan who said that.
Because they're spies, or there could be spies.
There could be.
But there weren't.
But they're German Americans, there's Italian Americans. They're cool.
It's okay.
Because power.
But Japan was the one that bombed us.
There is an issue because of Pearl Harbor. But, you know, it's funny, something that was suppressed and we don't find out about to the Freedom of Information Act, we don't find out until, I think, 2005, I could be wrong on that date. We find out the U.S. Navy commissioned a report to find out, are Japanese Americans likely or unlikely to commit espionage? And the U.S. Navy discovered there is almost a complete unlikelihood that Japanese Americans would ever actually be spies. But the federal government in 1944 suppressed that report. They hid it. The Supreme Court never saw that report. Never saw it. Right? Under the Freedom of Information Act, it's only come of light in the last few years that we know that report was hidden. Right? The U.S. Navy concluded there's no way these people are going to be spies. Right? But people want revenge. People want payback. Right? And that's what kind of happens here. Executive Order 9066. Remember, that's a law that the President can make without Congress. But it has to be in some area that the Executive Branch has oversight over. In wartime, what does the President have? War powers. So that's how he's able to issue this Executive Order 9066. He orders the internment of all these Japanese, mostly in California, right? These internment camps. Taken away from their homes, taken away from their lives, taken away from their jobs, their schools, right? And treated like they are exactly what you're saying, traitors. They're treated like the entire group of them, simply guilt by ethnicity, right? No, not fair. Not even American, if you think about it. Not even what the country's supposed to stand for.
Isn't it ironic?
Isn't it ironic? I don't think that's actually irony. I think that's just horrible sadness. All right, the Warren Court. We're getting into the modern era. Earl Warren was a Republican. He was appointed by Dwight Eisenhower, turned into one of our most liberal judges they about ever had. Cases that we've already dealt with, the Brown versus Topeka, that overturns Plessy. Right? So it ends segregation where? In public schools. Right? This is where we also have this massive increase of private schools in America after that. Right? The South becomes defiant. And they will not do this. And they start creating private schools. In the Schenck case, we talked earlier about clear and present danger. They put limits on it in the Yates versus the United States, 1957. Free speech is protected. And is only limited if it poses an actual danger to the public. For instance, hate speech. Can you give a speech that's very hateful and be protected by the First Amendment? The answer is yes. I know I'm not talking to you about it, but it actually is yes. Can the KKK have a rally and give a speech? Yes. They're protected by the First Amendment. However, if it poses a danger, if you now take that speech and start advocating death to somebody, that's no longer protected. That's now where the Supreme Court narrowed clear and present danger. It must be an actual threat to the public. Ingo versus Vitale, 1962. We'll talk about this again when we do our review on religion. Right? Should there be prayer in the public school system? Right? Well, the Constitution guarantees a separation of church and state. Right? There is no official religion to the state for the United States of America. Having students of various religious backgrounds and non-religious backgrounds and forcing them to say a prayer, the Supreme Court said, well, we're not going to do that. And that's still to this day an extremely controversial case, right? Conservatives today, they would like to overthrow this case. A lot of people say we got to bring prayer back in because that's what's led to juvenile delinquency. I think it's too much candy bars in the vending machines. And in here are the three cases that eventually lead to your Miranda rights. And I don't like it when you guys know your Miranda rights by heart, so I won't ask you. It's scary. Gideon happened in Florida. Yeah. Gideon happened in upstate Florida. He broke into a pool hall. He did. He actually broke into the pool hall in the middle of the night, stole money, was arrested. He couldn't afford an attorney. The judge in Florida said, you got to defend yourself. Guilty, goes to jail. When you're in jail, you get free education. He starts to read law books. He starts to read law cases. And he realizes he should have been given a court-appointed attorney. He starts writing letters to the Supreme Court. Eventually, the Supreme Court listens to him and says, yes, he deserves a new trial because he was denied a basic civil liberty. Now, you might say to yourself, yeah, but he committed a crime. But the idea is, what if this happened to you and you did not commit a crime? Right? And you do not get a right to an attorney. The precedent would already be set. So the Supreme Court is trying to protect innocent people when they do this. In all these cases, these are guilty people. Danny Escobedo killed his brother-in-law. Shot and killed his brother-in-law because he was beating up his sister all the time. He was an abusive husband. He was beating up his sister all the time. So Danny and his sister plotted and they murdered the guy. Well, he gets arrested. The police start heavily questioning this man. They actually arrest him twice because they can't find evidence on him. The attorney, right, is not allowed to be in the room. The attorney shows up at the police station begging to get in the room with his client. Danny is asking for his attorney. The police say no. The police used to be allowed to do something called the third degree. I could give you the third degree. I don't know if you ever heard these old movies where they beat you with a rubber hose. They'd have you in a dark room with a light over you, right? And make you sweat it out. They'd burn cigarettes on your arm. They can do anything they want at a particular moment. That's why the Supreme Court gets involved here. Why an attorney must be present, so the police cannot give you the third degree. Police begin to dislike the Supreme Court because they don't like their power being limited. And of course, the famous Miranda case, right? He sexually raped and murdered a woman, okay? But again, he was denied his right to an attorney. These are situations where, yeah, they were guilty, but what happens if this happens to innocent people? Right? So now you know, when you're arrested, you have your Miranda rights, right? That's where you get them from. They all stem from all three cases, by the way. All three cases eventually add to this Miranda right issue that we have today. All this came under the Warren Court. And there's the Supreme Court today. Interesting makeup of the Supreme Court today. There are 6 Roman Catholics and 3 Jewish judges. There is not a single Protestant religion up there anymore. The first time in American history, you do not have a judge who's a Baptist, a Methodist, a Lutheran, Presbyterian, Assembly of God, non-denominational, whatever Protestant religion is out there. This is the first time in our history we have 6 Roman Catholics and 3 Jewish people who are the sit on the Supreme Court. Don't know if that means anything or not. Does anybody know the name of the Chief Justice? I didn't think so. John Roberts.
Hey, it's my brother, another John.
Another John. You can never go wrong with John. It seems like in American history, right? We have 3 women on the Supreme Court. Sotomayor, Kagan, and Gingrich. We have African American in Clarence Thomas, an Italian in Scalia. I think Attoli, I wrote it down because I knew I'd forget, and Breyer, and that's Kennedy. Some of these men were appointed by Ronald Reagan. That's all I've been sitting. All right, well that brings us to an end to the Supreme Court. Thank you. Thank you. Appreciate it. Love the applause. Woo! I mean, turn it off.